to take a seat. We're going to get started, please. Good morning, and welcome to this Sunshine Week event sponsored by Citizens for Responsibility and Ethics in Washington and George Washington University law professor Alan Morrison. Public debate over the use of torture on detainees was severely hampered when the Bush administration refused to disclose the highly controversial analyses done by the Justice Department's Office of Legal Counsel, which concluded that torture was consistent with U.S. laws and treaty obligations. Although the OLC torture memos addressed fundamental questions of national policy, they were off limits to the public until President Obama ordered their release in April of 2009. Today, we face a similar controversy over the refusal of the Obama administration to publicly release OLC opinions that authorize the killing of Americans on foreign soil suspected of terrorism. The public outcry over this practice is no less substantial than the outcry over the torture of detainees. By depriving the public of the rationale for these controversial practices, the administration is following a disturbing trend toward more secrecy and less accountability. That is why we thought it appropriate to look at this subject in more depth as part of our observation of Sunshine Week. Toward that end, we have two terrific panels. The first, made up of a journalist and two lawyers who are litigating over access to OLC opinions, and the second, made up of a former head of OLC and two noted constitutional scholars. And they will be introduced individually in a short while. But first, we are extraordinarily honored to hear from the Honorable Ron Wyden, the Democratic senator from Oregon. A graduate of Stanford University and the University of Oregon School of Law, Senator Wyden served in the U.S. House of Representatives from 1981 until his election to the Senate in 1996. He has been a courageous leader in Congress in the fight against government secrecy. Unafraid to take controversial and at times unpopular positions, Senator Wyden has condemned the national security community's abuses of secrecy and forced the declassification of the CIA Inspector General's 9/11 report. He has shut down the controversial Total Information Awareness Program and spotlighted the reliance by both the Bush and Obama administrations on secret law. I commend to you the letter Senator Wyden co-authored asking President Obama to direct the Justice Department to provide Congress with all legal opinions that explain the executive branch's understanding of the authority the President has to deliberately kill American citizens. Senator Wyden followed up with a similar letter to the Attorney General, in which he elegantly stated, "The only way to keep the terrible mistakes of the past from being repeated is to have executive branch officials continually resist the temptation to rely on secret law, and for Congress and the public to continually insist on greater transparency." I can think of no greater honor than to have Senator Wyden kick off our Sunshine Week event. As a champion of government transparency and accountability, he embodies the values many of us spend our waking hours working towards. So please join me in giving a very warm welcome to Senator Ron Wyden.
What an inflationary introduction, and thank you so much. I think it is great to be here for this Sunshine Week event. Crew and GW and Alan Morrison. What you should know, I'm going to make some news here. Where is Bruce Fine? I don't know how many of you are aware of the great work Bruce has done in the privacy area and having been a voice for individual liberty. But I want to say for the first time publicly in Washington, D.C., that Bruce and I met first when we played basketball one-on-one all summer long in Palo Alto, California. And suffice it to say that Bruce, who has brought great discipline to the whole area of liberty and scholarship, clearly showed that as well on the basketball court as well. I'll tell other stories about basketball if I'm given a chance. Bruce doesn't even know the story, but recently there was discussion about Jeremy Lin getting his own bathroom in Palo Alto because everybody played basketball at this one court, and it was going to be called the Lin Lou. And people wrote in and said Ron Wyden ought to be able to get his own bathroom as well because he played basketball as well. And then there was considerable debate, which really was resolved by saying Ron Wyden is okay as a United States Senator, but he doesn't deserve his own bathroom of American politics. So let me use this as a time to sort of walk you back a little bit through where we have been in this whole kind of saga, because I think we all understand that American lawmaking under sort of any calculus is cumbersome and it's frustrating. One of my colleagues says that it is the ultimate slow burn to watch this whole question of passing laws. But at the same time, this process, if you look back over history, is also a pretty good way to ensure that the laws have the support of most Americans, because they usually don't get passed unless you have people brought into the dialogue and brought into the discussion. That's, in my view, what legislating is all about in our unique system of government. Having said that, what has been the issue, I think, that has joined us, particularly in this meeting about Sunshine Week, is that process that I've described can break down in a hurry if our laws, which are public, are secretly reinterpreted behind closed doors by a small number of government officials without public scrutiny or without debate. And when that kind of thing happens, you are more likely to end up with the government interpreting the law in ways that the American people will be, in many instances, reluctant to accept. So let me kind of use that as a kind of backdrop for this discussion to then say that I have long argued, as part of this discussion that we have been having for a number of years now, that there are certainly legitimate reasons for government agencies to keep certain information secret. In a democratic society, citizens rightly expect that their government is not going to keep information from them arbitrarily, and throughout our history we have guarded zealously our right to know. But there are certainly exceptions that you can think of very quickly to this principle of openness. For example, most Americans would acknowledge that tax collectors need to have access to individuals' financial records, but they do not believe that their government has a right or a need to share this information openly. So let's kind of set that over here as an exception to protect personal privacy. Another limited exception would certainly fall in the area of protecting national security. Our government has a responsibility to protect citizens from threats to their safety, and sometimes that requires secret operations. And in this discussion, I think if there's one point that I could convey, it is that secret operations are different than secret law. Let me repeat that again. Secret operations are different than secret law, and for obvious reasons. We've got men and women in the intelligence community who are doing important work for our country, and if their operations suddenly are all over hither and yon, the web and elsewhere, they can lose their lives. Our country's security can be jeopardized. That is very different than the concept of our laws being kept secret, because our laws, by nature of the way we write them, laws are public. And you sit at your laptop. I saw lots of students outside. They were at their laptops, and they can type away a little bit, and they can get access to a public law. And the question is, what happens when that public law is interpreted secretly? And that is what has been at issue. So just as I don't expect U.S. generals to publicly discuss the details of troop movements in Afghanistan any more than early Americans expected George Washington to publish his strategy for the Battle of Yorktown, we are continuing to make the case that very often the collection of intelligence, to be effective, the details have to remain secret, and that what are called sources and methods are in a very different kind of basket than the question of keeping the law secret. I was on Rachel Maddow's show last week, and part of the whole debate about Rand Paul's filibuster, and she picked up early on the question of the difference between secret operations and secret law. And I just want to, as part of this debate, to say that I, and I think many others, are trying to convey that we aren't going to take a back seat to anybody, not anybody, in the question of protecting genuinely sensitive sources and operations, but I am also not going to take a back seat to anybody in the effort to try to make sure that our public laws stay public. And that is, in effect, what this discussion is all about. And we could take plenty, of examples of exactly what, the consequences are. I mean, I'm also the chair of the Energy and Natural Resources Committee. 50% of my state is owned by the federal government. So we care a lot about, for example, the Forest Service. If the Forest Service interprets a law in an unusual way, it is likely to become public very quickly. If the CIA or the NSA interprets a law in an unusual fashion, it might well stay secret for years. And that is what has happened in the past. If you look at the scandals of the 60s and the 70s, the spying scandals, as well as Iran-Contra, the warrantless wiretapping and coercive interrogation programs of the past decade, much of that narrative involves government officials secretly deciding that the law didn't mean what most people thought it meant. And in order to prevent mistakes and abuses like those from recurring, I believe the Congress and the public have to insist that the executive branch's official interpretation of the law be publicly, known. And I'm going to use those words, official interpretation, because we're going to have discussions about other concepts. The President and I, for example, have discussed pre-decisional, materials. There are a variety of other concepts here. What we have been concerned about is the executive branch's official interpretation of public laws being publicly known and understood. So, with respect to the Office of Legal Counsel, as many of you know, this is a unit within the Department of Justice. They provide authoritative legal advice to the President and all of the agencies in the executive branch. Now, when officials within the executive branch want to know whether a particular action would be legal, they, in effect, can rely on the Office of Legal Counsel, the OLC. And if you want to get their official interpretation of a law, usually you can find it contained in a written opinion from the OLC. Much of their work is public. Go to their website, you'll see new opinions are posted all the time. You can have opinions posted on firearms law, veterans benefits, and lottery tickets. And some of these publicly available opinions deal with matters of national security, including whether the President was authorized to conduct airstrikes in Libya. But there are also a number of OLC opinions that are secret and withheld not just from the public, but from the Congress as well. So 2 years ago, I asked the Director of National Intelligence for the official legal analysis of the executive branch's authority. No one reaches for water anymore now without referencing Marco Rubio. But I will not. 2 years ago, I asked the Director of National Intelligence for the official legal analysis of the executive branch's authority to deliberately kill Americans in the course of counter-terror operations. Now, I said on the floor, I'll say again, that if individual Americans choose to take up arms against the United States, there is no question in my mind that there are circumstances where the president has the authority to use military force against them. But it is also important for the president and the Congress and the public to understand what the executive branch thinks the limits and boundaries of this authority are, and that is the only way that you can assure that the authority is subject to appropriate limitations and safeguards. And I have tried to sum this up, having talked on this a number of times, that I think every American has the right to know when their government believes it is allowed to kill them. That is, to me, where the heart of this discussion is. When I talk to people, I go, so do you believe in that principle or not? Because I think that is right at the heart of this discussion. So when I started this 2-year odyssey that finally ended after 7 requests, I was told that what we wanted to know was contained in these secret opinions written by the OLC. And then we asked about them. We asked about them orally. We asked about them in writing. The executive branch offered up summaries of their analyses, briefings on their analyses, and pretty much everything except the opinions. And eventually, having talked to my colleagues on the committee, and the Brennan nomination came up before the Senate, we were in a position to convince a number of Senate colleagues that we absolutely had to have these opinions to fulfill our oversight responsibilities. And I said, we need those opinions before there is a vote on Mr. Brennan to head the CIA, and we got those opinions. Now, I'm going to have more to say about the contents of the documents once we've had a little bit more time to review them. But to me, there is an important point that has been established, and that is that finally we've taken a significant step forward by establishing a precedent for applying our system of checks and balances to the challenges of warfare in the 21st century. And I think in the Senate, I sometimes talk to colleagues about the value of a checks and balances caucus, because there are a group of us, Democrats and Republicans, who sort of see our role as being that, and this was a valuable precedent, a win for our side. Now, my guess is some of you are saying, why did it take the executive branch so long to provide these documents? What was the resistance about? You just heard 7 requests, a 2-year period, number of senators being involved. The president himself saying to me and to others that he wanted to promote transparency and openness. My guess, having kind of walked back a little bit, what happened and who said what, is that there is certainly a debate going on within the executive branch on this issue. There are some within the executive branch who simply are worried that providing the documents sets precedent that would undermine the president's ability to get candid legal advice. And that's why we get into this question of exactly what it is we've been looking for and sort of trying to describe the documents at issue. So to me, the president is absolutely entitled to receive confidential legal counsel, and there is no reason why the President of the United States ought to be forced to give to the Congress documents containing pre-decisional legal advice. That is very different than when the President makes a decision to take a particular action or approve a particular program, and the OLC sends a government agency a memo that explains why the decision is legal. You are no longer at that point talking about pre-decisional legal advice. It is the government's official interpretation of what the law means. It is what the law authorizes. It is different than sort of the prelims, the pre-decisional kinds of questions. And I strongly believe that that legal analysis needs to be made available to the Congress and to the public, because the Congress and the American people need to know what the executive branch thinks the law and the Constitution allow them to do. And I think this is especially true in the area of intelligence and national security policy, where you heard me say that it is important because so much of the operations of the intelligence community have to be kept secret. That increases my interest in trying to ensure that the interpretation of the law, not the details about what they're doing in an operation, the interpretation of the law is public. And I'm sure that there are some in the executive branch who are well-meaning, who say that keeping official interpretations of the law secret, that is absolutely necessary, because somehow if the nature of our public laws is described, that this is going to help our country's adversaries figure out what the government is allowed to do. The only thing is, if you buy into that kind of Alice in Wonderland logic, if the government adopts it, it would essentially mean that all sorts of laws would be secret, because that would be even more useful. For example, when the Congress passed the Foreign Intelligence Surveillance Act in 1978, it would have been useful to keep the law secret from the KGB so that Soviet agents wouldn't know whether the FBI was allowed to track them. But American laws and the Constitution shouldn't be public only when the government thinks it's convenient. The laws ought to be public all the time, and every citizen ought to be able to find out what their government thinks the laws mean. And that is why your work and this discussion is so important. And I will just tell you what I've just stated is sort of my North Star. This has been my principle for my 12 years on the Senate Intelligence Committee. And this is what we try to do when we try to navigate the questions about how to balance the government's need for secrecy when there are secret operations and lives at stake with the public's right to know. And I'm glad that you're going to help us find some more creative kinds of answers as we try to strike this balance. I mean, this balance I'm talking about can also be compared to a constitutional teeter-totter. Where over here you have security, over here you have, liberty, and Ben Franklin and others have been debating this, for years. And the system works really well if the teeter-totter can kind of stay in whack. And it's when the teeter-totter starts moving in these out-of-balance kind of gyrations, that's when I think our values and our liberties are particularly in jeopardy. So let me use that as kind of an opening salvo. I understand you have a panel and you probably want to get on with it. If anyone has a question, softball questions are always especially welcome. And we'll just take a question or two. We'll go right there. And yeah, go ahead.
Hi, it's Sharon Bradford from the Constitution Project. I want to applaud you for all this work, and I fully agree with all the lines you've laid out. I'm curious to the extent that you can share with us, and maybe you can't, this line that you've drawn between secret operations and secret law. When you're negotiating with the executive branch, are they disagreeing with that in principle, or are they arguing that when you look at these OLC opinions, they're so infected with the facts that they can't turn over the part that actually shows the law?
Well, there's been a considerable amount of discussion about how this is somehow intertwined, that there really is no such thing as a difference between the law and the factual nature of how you describe a particular operation. I don't buy that, and I don't buy that for a second, and having read now some of these materials, it's pretty clear. They involve the law. And I think we also have made the argument that if there is anything that would intertwine operations with the law and the law was public, that's what we have redaction for. So this is not, I think, the showstopper that some would want. Oh my goodness, everything is really secret operations, and we can't separate out the law from the secret operations. We've got another example in terms of what we've read that shows that can be done. Yeah.
Laura Jakes with Associated Press. So just to kind of piggyback on that, what has been the legal standard heretofore of the government being allowed to kill Americans? You're smiling, but if the OLC memos are rooted in law, what is that law?
Well, what the questions have been all about is the Congress is really kind of in the dark on that point. And I'm going to be asking some additional questions now, having had a chance to at least go through the documents once. Were you at the Brennan hearing?
No, but I was at the hearing yesterday. So.
Okay. So what I do, especially when we get one of those rare creatures known as an open hearing, I try to do everything I can to try to excavate details with respect to how we would answer your questions. For example, when Mr. Brennan was there for the hearing, I asked him about the definition essential to what kind of evidentiary standard would be relevant. And when I tell you about the questions, I'll tell you what he said. I asked questions with respect to capture and surrender and everything I could think of that would allow me to get more detail about exactly what the government is doing. And I thought the answers were exceptionally vague. I mean, my favorite one was a long response where he said in one sentence, we are optimizing secrecy and we are optimizing transparency in the same sentence. Okay? Let me just finish. The particularly detailed focus that I had that day, where I just went at it and went at it and went at it, was we still do not have a public accounting of what country's lethal force has been used. And so I asked at the hearing, I asked it repeatedly at the hearing, and finally he said, well, Senator, you can be sure if I'm confirmed, I'll tell you if there's any country where lethal force is used, which of course was not, the question. So what I try to do, and I did it again yesterday with respect to two questions, the statement that had been made by the National Security Advisor, General Alexander, with respect to something I'd never heard used before, the question of dossiers, and I asked exactly what they meant. And then we'll be asking more questions with respect to the warrants that the Intelligence Committee uses or doesn't use. And I pointed out that FISA doesn't specify a warrant. And I was particularly struck what was noteworthy about yesterday, and I'm not sure, I haven't seen all the papers and wire services and all the rest, but I thought the Attorney General's response on that was particularly telling, because he said the courts are going to interpret what the warrant requirements are and evidence, or there are circumstances where neither is required. And I think you heard me say, well, I think that's right. What are people going to do about their rights while we're waiting for the courts to flush it out? So I've got a lot more to do in terms of just staying at it. But the reason I keep asking all these questions is because the answers are so vague and inadequate. And we win battles, and we've won a couple of really big ones here in the last year. I think didn't get quite as much attention at the end of the year, but you all might have reported on it. I had put a hold on the Intelligence Authorization Bill because of these provisions that were supposed to be fighting leaks, and most of what they did was damage the public's right to know. Nobody thought we had a chance on that, and because we spent the better part of 6 months trying to lay out the consequences, we won a complete victory on it. They were all removed. So we won that, and we won the effort to get the OLC documents. But I'm convinced that, I'll let you follow up, we got a lot more to do to be able to tell someone like yourself and to tell Americans, here's the evidentiary standard, here are the rules with respect to capture, here are the countries where lethal force, and I'm just going to keep asking the questions and pressing the case until we get it. So, go ahead.
So just very quickly, I mean, if you're Joe American or law student Susie and you're student Susie and you want to look at Title 18 or whatever to see what exactly the law says, there is really nothing in there at this point, correct? There's no legal standard that says, one clear legal standard that says this is the case in which the government can kill an American.
That's right.
Yeah. Yeah. And that is why, I mean, clearly the question I asked in the committee with respect to geographic, limitations and the ability to use lethal force in the United States, we know a bit more now than we did 2 weeks ago. The line has sort of been vaguely articulated that if you're talking about a non-combatant in the United States, that is different, for example, than the question of trying to deal with an imminent threat along the lines of 9/11 or Pearl Harbor. But I will just tell you, I think this debate is just beginning in terms of trying to actually answer the question you have asked. You've said, where does an American go to actually see what the standard is? And the answer, is that has not, been laid out. And in fact, I thought a number of the responses to questions that I asked, particularly at the Brennan hearing, when I was trying to get the administration on record on that point, were so vague, and particularly that sentence, and you can get it out of the transcript, where they said in the same sentence, we're going to maximize transparency and maximize secrecy as their response to make it clear that the answer to the question, which is the way I frame it, that Americans have a right to know when their government believes it's allowed to kill them. We got a long way to go to have that question answered.
I can see that we could have had a whole program with the senator, and I regret that we don't have the time because we have 2 great panels lined up. But I think you've offered some really insightful comments and a great way to sort of start our conversation. So I very much appreciate you joining us.
Thanks a lot.
Thank you.
Thanks for having me.
We're going to get started with our first panel. So I'm going to ask the first panelist to come up.
Senator, what kind of conditions do they put on the documents? Do you release them?
Let's put it this way. I'm going to spend a lot of time trying to declassify a significant portion of this, including matters related to drones.
Thank you.
Yeah, we've been working with you guys a long time.
Yeah, it's incredible stuff.
Good. We'll be working with you. Charlie, see you soon.
I really do think that Senator Wyden did such a wonderful job of, in layman's terms, capturing what the issue is. And I think it is a great jumping off point for our first panel. So let me introduce them. We have, to my immediate right is Charlie Savage, who is a Pulitzer Prize winning journalist for the New York Times. He began his career with the Miami Herald as a local government and politics reporter, went on to the Boston Globe, where he received the Pulitzer Prize for national reporting. And he is also a plaintiff in a lawsuit against the Department of Justice that seeks access to the OLC opinions justifying the targeted killing of individuals abroad. He's written about the subject extensively. In fact, just last Sunday, there was an article he co-authored about this very subject. Next to him is David Sobel, who is Senior Counsel at the Electronic Frontier Foundation's Washington, D.C. office, where he directs the FOIA litigation for Accountable Government Project. David has handled a number of cases seeking disclosure of government documents, and currently also is litigating another FOIA lawsuit that seeks access to an OLC opinion on the scope of the FBI's authority under federal surveillance laws. He's former counsel to the National Security Archive and co-founded the Electronic Privacy Information Center. And next to him is Jamil Jafar, who is the Deputy Legal Director at the ACLU, and he also is Director of their Center for Democracy, which houses the ACLU's work on national security, human rights, speech, privacy, and technology. Jamil continues to actively litigate cases that he brought while he was director of the ACLU's National Security Project, and one of those cases is a challenge to the CIA's authority to carry out targeted killings outside the context of armed conflict. Currently, he is on a writing leave, although he was gracious enough to agree to be on this panel, and we're very grateful. He's also a fellow at the Open Society Foundation and a visiting fellow at Yale Law School's Information Society Project. So let's just jump right in, and I guess, Charlie, I would start with you. Senator Wyden talked a lot about the targeted killing OLC memos. I know that's the subject of your lawsuit. But at this point in time, we have a lot more information than we did when you first filed your FOIA request and lawsuit. The white paper has been leaked, and that appears to lay out a fairly detailed legal justification for the administration's policy. So I guess my question to you is, why do we need more? Why do we need these memos? What will they add that we don't already have?
The memos on targeted killing of
Yes.
Americans in particular? Well, we certainly know more than we knew a year and a half ago, but when Aleki was first killed and we filed our lawsuit shortly after with ACLU filing their version as well, and it got sort of consolidated. I would suggest that the devil's in the details of a lot of this stuff, and we don't really know still some of the most important questions, such as, what counts as infeasibility of capture, what counts as imminence. There's the white paper has this vague language about, at least in the situation where you have a presumed terrorist who's in the business of continually coming up with attacks, and a window of opportunity arises when the drone spots him and he might slip away again, that you don't have to have specific evidence that anything is immediately about to happen for the imminence requirement to have been met. It's also not clear actually why imminence and when imminence is a consideration that comes into play and doesn't. Everything is all sort of tangled up and confused in the white paper because it was extracted from the real memo and was written in a way that once it's divorced from the facts and the context of the question that was being asked in the real memo, it becomes hard to understand exactly what their theory is and how it might have general applicability as opposed to the specifics of Aleki as an individual.
But when you get into that level of detail, isn't that where you're more likely to bump up against classified information that could reveal sources and methods, for example?
Well, certainly the intelligence about what they thought Aleki was up to and why they thought that. This cell phone was being intercepted. That there's those sorts of facts do bump up into sources and methods. Although it's been, the guy's been dead almost 2 years now, right? So it's not clear to me whether the source and method sensitivity is permanent or has a shelf life. And I would also just sort of throw in there that what part of what we know now about the legal reasoning, in particular with regard to federal statutes, the murder statute and the overseas murder statute that came into play, is important to know because, for example, we now know that they did not go to a sort of Bush administration style commander-in-chief override theory where, because the president is the commander-in-chief and this is a national security situation, Congress cannot regulate in this area. Congress simply cannot constrain what the president is going to do in the conduct of this military operation. We know that they instead went into, this is in the weeds, but they went into a public authority style doctrine, which means that Congress just hasn't regulated this kind of context. But Congress could if it wanted to. And you have to know that for Congress to then decide whether the interpretation that Congress's anti-killing statutes just don't reach this situation is in fact what lawmakers intended to be doing, and if they want to change that, they have to know that they have the opportunity to. And so this is why down in the weeds of the memos, suddenly everything matters.
Well, Jamil, let me ask you, because you have a companion lawsuit there. So we already had a decision from the district court rejecting, agreeing with the government that all of this material can be withheld. And of course, you're asking for far more than just the OLC memos. But reading the judge's opinion, she's pretty tortured. I mean, it's clear that she is very troubled by the underlying practices, but believes that the state of FOIA law kind of compel her to conclude that the memos can't be disclosed. Where is she wrong on that, just from a FOIA law perspective?
Well, I mean, you're right. The decision is, the judge is tortured, and the decision is pretty convoluted. And you know, we are appealing the decision. We think it's wrong in a number of different ways. On the legal memos in particular, you know, our view is that the government has adopted this legal analysis as policy, and once you have adopted the legal analysis as policy, it becomes disclosable. Or no longer withholdable anyway, under the relevant exemption. And so I think that there's a strong argument that under FOIA the judge got it wrong. I think that there's a larger argument about independent of FOIA, just in terms of what makes sense in a democracy. Should the public know about this kind of thing or not? And for many of the reasons that Senator Wyden was laying out, we think it's important that the public know the scope of the authority that the government is claiming. If I could just take that opportunity to say that I don't think we should be too quick to accept the government's distinction between legal authority on the one hand, or legal analysis on the one hand, and operational information on the other hand, in part because the government takes a very broad view of what counts as operational information, but also because sometimes the public interest in disclosure of operational information is pretty significant. And I think the government itself has recognized that. You see the government, for example, disclosing information about the bin Laden raid, right? Operational information about the bin Laden raid. And obviously somebody has made the judgment that there is an overriding public interest in disclosure of that information. And then, Charlie, who's done more than almost anyone to get information about this set of policies out into the public domain, Charlie quotes government officials all the time talking on the record or off the record about operational information. And so sometimes the resort to operational information, that phrase, is not really about keeping secret information that should be secret, but rather insulating officials from accountability for decisions that they've made. So I do think there's a distinction between law and fact, and it's a useful sort of first line distinction. But I don't think that at the end of the day that distinction can be what determines what gets made public and what doesn't.
Well, David, let me bring you into this discussion. You're after different OLC memos, but I think the same issues underlie all these cases. And I mean, one of the things, even if one were to agree with you with what's been said so far, we're talking about using the courts to compel the executive branch to disclose something that it is determined it thinks it's not in its best interest to disclose. And that gets us in part into issues of separation of powers and executive authority, whether or not this administration is hanging its hat solely on the power of the executive. So how do you balance those interests? Where do we draw those lines? How do we accommodate those, what you have to concede at some point are legitimate interests?
Well, I would refer to what Senator Wyden said in terms of the fact that this is the executive branch's interpretation of what the law is. So I don't really think there's a separation of powers issue more than there is with respect to any issue that arises under FOIA. I mean, this goes back to the 1974 amendments of FOIA, which President Ford vetoed, partially because of concerns that, interestingly, were expressed at the time by his chief of staff, Dick Cheney, about the separation of power issue with respect to Congress mandating disclosure of executive branch material and the concerns that executive privilege issues would bring to bear under that framework. So that's a tension that I think exists with respect to any issue under FOIA. But in many of the instances where we're talking about OLC opinions as opposed to deliberative material that might be generated in the internal process within OLC of coming to a determination as to what the law is. When you're talking about the opinion, the final product of the deliberative process, I don't really think there's that concern. Executive privilege is, in FOIA, in the context of FOIA, really thought of as part of the deliberative process privilege under Exemption 5. And some of us might disagree about this, but within EFF's pending lawsuit for the OLC opinion that we're seeking, we have acknowledged that material generated within OLC during the process of arriving at a final opinion, which reflects, as the courts refer to it, the give and take of agency consideration of an issue. That material, the preliminary material, the pre-decisional material, might very well be legitimately withheld under the privilege. But when you're talking about the final product of that process, I don't think the deliberative process privilege and the arguments underlying it and the objectives of it really come into play. So when you're talking about a final product, I think the separation of powers issues are not as strong as they are in other situations that arise under FOIA.
So I throw this out to any of you. I don't think the court has yet ordered the disclosure of an OLC opinion, have they? So why not? Well, why are the courts continually getting this issue wrong?
Jamil can probably talk about the situation in the Second Circuit, which has gone. I'm not trying to avoid the question. I just say that as a matter of precedent within the circuits that our cases are pending in, the D.C. Circuit, interestingly, has not really squarely addressed this issue. The lower courts in D.C., the district court in D.C., has, and as you say, that has not been a very favorable trend within the district court decisions here. The Second Circuit in the last several years has dealt with the issue a little bit more directly at the appellate level, and the results there have been mixed, but there have been Second Circuit directives that OLC material be released. So if you want to talk more about that.
You're definitely right that the rule is that the courts defer to the executive. I think that is part of a larger issue relating to national security and democratic rights. I mean, the courts have been extraordinarily deferential to the executive on national security issues generally, and I think this is part of that pattern. I'm not sure that it. I don't think it's any different than the situation in FOIA is any different than it is with constitutional cases. And I think that this is, it's something that differentiates American courts now from the courts in many other democracies. In many other democracies, in Canada, in the UK, in Israel, the courts have been much more involved in determining whether substantive national security policy is consistent with individual rights, with democratic rights. But that's something that has not happened in the United States. Instead, we've sort of gone in the other direction. And whereas you had 50 years ago the Supreme Court actually getting its hands dirty in some national security issues, what you have now in the United States is the federal courts finding almost any reason to throw cases out of the threshold. And again, that's true generally, not just in FOIA cases, but in FOIA cases, as you said, the rule is that the courts are not accepting the argument that legal analysis should be disclosed.
If I could jump in, I'm not a lawyer, a plaintiff who has a lawyer, unlike the other two here. But as I understand it, at least in the Second Circuit, what has developed is the thought that even final OLC analysis is still pre-decision. Right. It's still deliberative, because the policy decision is when the president or the agency or head, does X, appoints makes recess appointments despite pro forma sessions or something, orders the killing of Anwar Alaki. And when he does that, he might have an OLC memo in front of him that says you can do it and here's why. But it doesn't even necessarily follow that his decision was because of this OLC memo. Maybe he has an entirely different rationale in his head when he makes that decision. And so the OLC advice can never be anything but pre-decisional and deliberative.
That does seem to be where they've gone.
Well, let me just add with respect to the Second Circuit, because the Second Circuit, as I said, has directed the disclosure of OLC material. In the La Raza case, under the theory that the OLC opinion had been adopted.
Right.
And in that case, the issue was an OLC opinion dealing with application of federal immigration law at the local level. And the circumstances surrounding that were that Attorney General Ashcroft and other Justice Department officials had made public reference to the fact that the Bush administration policy on that issue had been developed basically along the lines of the OLC opinion that they were referencing. So that public reference and that public reliance upon the OLC opinion led the court to basically say that because it had been publicly adopted and touted as the reason, publicly touted as the reason for official action, that any protection that the opinion might otherwise have was lost through that process of adoption.
That's true, but I think it's also been very narrowly interpreted.
It has.
Exception. The agency has to say, we did this because of the OLC memo.
Right.
And they have to
not just an OLC memo exists, even.
Right.
Talk about the contents of the memo.
They have to refer to the specific memo too. That's what Judge McMahon said in these two cases that have been consolidated. Judge McMahon said it's not enough that they have talked about the legal analysis and referenced a memo. You can't show that the memo that they have now acknowledged in litigation is the same memo that they're talking about publicly. So it's a very narrow, narrow version of the adoption memo.
And not only that, so one of our lawsuits is for recess appointment related OLC memos that OLC itself cited as authority in its subsequent memo on President Obama's controversial appointments when the Senate was in pro forma session. And so very often what you find in the world of executive branch lawyering is that there's very little court precedent because these issues are rarely justiciable. There's rarely someone who has standing to bring a lawsuit. And the way this world works is that OLC, why it's so different, why people like us think it's not just legal analysis, but it is policy, is that OLC decides these things for itself, what is the law and what are the parameters, and then it cites previous decisions by executive branch lawyers. It sort of agrees with itself, sometimes even across administrations, to assemble this giant chain of, yes, the executive branch thinks it can do this without any sort of other branch reviewing it. So what we saw in the recess appointment memo was it linked back to some previously undisclosed memos, one by Jack Goldsmith in 2004, when President Bush appointed William Pryor, for example, to the appeals court with a recess appointment, and said, look, we can do this because there's precedent. See this memo, right, as if that were a Supreme Court ruling. And so we FOIA'd for those, and this is not classified, this is not national security, and the memo's existence has been disclosed and referenced as public authority. And even then, the argument was, well, because this is sort of one step removed from whatever would have gone into this particular set of appointments, you can't see that. Although they were nice enough to give us a copy of the memo. Here it is. We can see that Alberto Gonzalez had asked Jack Goldsmith about whether the president may make recess appointments during the current intersessions, and that they believe he may. And that if there's anything else that Jack could be of assistance. So that was very illuminating for our public discussion, and we appreciate that very much.
Let me pause at this point and just see if there are any questions out there from any of you. Please feel free to ask. Anybody? Yes.
Rahul Wall with Human Rights First. So you're kind of thinking out loud here, but I'm curious as to whether you think the focus on OLC in the targeted killing context, the focus on OLC memos as it pertains to the targeting of American citizens might be too narrow as a matter of thinking through the congressional oversight and public transparency questions. A couple of thoughts along those lines. One is that if you look at the broader targeted killing program and what we know about it factually, it appears that 4 Americans have been killed in the last decade or so, only one of which has been targeted. So presumably these opinions speak to literally one drone strike or targeted killing in the over 300 or 400 that have been conducted over a decade. The other piece of that, which is interesting, is that the white paper that was leaked didn't actually outline limitations on the authority. It basically just said, assuming there were restrictions that apply to Americans vis-a-vis the 4th and 5th Amendment, et cetera, the killing would nonetheless be justified. So in that sense, it may not actually have the policy restrictions that we're looking for. And so I think that's the American citizen piece, which is just it's a narrow slice. The OLC piece of whether that might be overly narrow is that there might actually be presidential policy directives, memorandums, policy guidance within DoD, CIA, that are not OLC opinions but are final policies of this administration that perhaps may not actually have that pre-decisional characteristic that has been attributed to OLC memos. So I guess I'll just leave it at that and welcome any observations you have as to whether we ought to be looking a little more broadly.
Yes, we should be. I mean, the 2 FOIA requests that we filed are the one in New York is not just about the OLC memos. It's about the 3 strikes that killed American citizens in Yemen. The other FOIA request that we have in D.C. is much broader, and it asks for information about, for example, civilian casualties, the process by which people are added to so-called kill lists. But our view at the ACLU is that disclosure of the legal memos is necessary but not sufficient. And you're right that the focus on U.S. citizens in particular is that's just a small slice of the larger policy, and we think that there ought to be more transparency with respect to the larger policy, not just with respect to strikes on U.S. citizens.
Just to add to that, so I take your point about maybe there's legal analysis that was not generated by OLC, as separate from your point about what about non-U.S. citizens. Yeah. Just to address the second one, our half of the now consolidated lawsuit actually derives from 2 different FOIA requests. One was by my colleague Scott Shane in 2010, and he asked for memos just on targeted killing generally, without distinction to U.S. citizens. And the second half was from mine from 2011, which asked for U.S. citizens specifically. Both of these were denied and led to a singular lawsuit. So I think the U.S. citizen element is a hook that gets people's attention more, both in terms of public interest and just because it adds so many more layers of legal complications to the mix, because now you've got to bring in federal statutes and constitutional rights. So that gets more attention, but I think the questions that are being asked are broader than that.
Yeah, maybe it's just worth pointing out, that we don't know, we don't know how many people have been killed with these drone strikes. We don't know in which countries they've been killed. We don't know who's making the decision to carry out those strikes. We don't know the legal analysis on which all of this is based. So, I think it's important that we learn the legal theory, that there's a lot more out there that in my view, ought to be said about the program.
Why did you file, the ACLU, the one lawsuit in D.C. and the other lawsuit in New York? Was that just arbitrary, or there was some strategic reason for that?
Well, they were filed, so the D.C. lawsuit was filed much earlier, right? We filed a FOIA request before the strikes, the Yemen strikes, and that killed U.S. citizens, and that was the broader FOIA request. Then we filed another request a little bit later, after the strikes in New York. I don't think that there was, sometimes just the way the ACLU works has to do with the affiliates, the state affiliates, and what the state affiliates are interested in at that particular time, and that's usually what drives our decision to file in one state rather than another.
If any other questions at this point? Well, David, let me ask you this. You've been litigating these kinds of issues for some time. Have you noticed any change or evolution in the government's position?
No, and I was going to make the point that, you know, sort of the political aspect of this and the promised changes that we were hoping to see under this administration certainly haven't come to pass. You know, we're approaching the 4th anniversary of the issuance of Attorney General Holder's memo on the supposedly new, more enlightened Obama administration FOIA policy and its implementation. And one of the points that grew out of that grows out of that memo and then subsequent Justice Department Office of Information Policy guidance that was even more specific in terms of implementation of the Obama policy, focused a lot on Exemption 5, which is, you know, what we're largely talking about here. I should make the point that obviously the memos that the OLC material we're talking about deals with classified material, but a lot of it doesn't. I mean, Charlie's discussion of the recess appointment issue, obviously that's not classified. So that kind of material, that kind of opinion is withheld solely under Exemption 5.
Which is what?
Which incorporates various privileges, the ones that are relevant to OLC opinions in terms of what DOJ invokes are the deliberative process privilege, which, as I said, is basically a form of executive privilege, and the attorney-client privilege. Now, the reason why that's relevant is because, as I said, the Obama administration, as first announced by the president the day after he was inaugurated the first time, and then subsequently repeated by the Attorney General and then by the Justice Department's Office of Information Policy, their focus has always been that with respect to Exemption 5 claims, because they are entirely discretionary, this would be an area where the Obama pro-transparency philosophy was going to be felt, you know, at its strongest. We certainly haven't seen that. Those of us who've been doing this for a long time have perceived really no change with respect to the policies that had been pursued in court by the Bush administration and that are now being pursued by the Obama administration. So I think that's an interesting and important point to make, that notwithstanding all of the fanfare that we've heard from this administration about a commitment to being the most transparent administration in history, those of us who are on the front lines of these lawsuits have certainly not seen that kind of change.
Just to piggyback off of that, you know, during the Bush years after the Office of Legal Counsel sort of became notorious with the leaking of the memos on torture and surveillance and the sort of broader unfederable executive power theories that it was advancing, brought this previously obscure chunk of the Justice Department into the public eye. A group of mainly Clinton administration OLC veterans came together and came up with this sort of policy statement about best principles for the office. And a big part of it was they should be disclosing their memos, publishing them much more frequently and much more quickly and much more often. And that spirit